Hello everyone. We've got a fairly small group, so if you want to come a little bit closer in, I would love that, but obviously social distancing is very important. I just don't project very well, so my name is Briar. I'm a lawyer in Brisbane in the intellectual property and technology team at HopgoodGanim Lawyers. My niche is games law, so I help mostly indie developers with their legals, navigating IP, developer contracts, creative contracts, publisher agreements, that sort of thing, which is what we're all going to get into now. Here we go. The agenda. So I'm going to talk about leveraging IP from a legal perspective. And the best way to do that is to talk about what legally IP is. When you talk about game IP, the industry has a very different definition to the legal definitions, and that can get some of my indie clients in trouble. Because when we're talking about protecting IP, sometimes what my developer clients think is IP is not actually, doesn't fit the traditional mold. Then we move on to leveraging that IP, and for me that means you're contracting and getting your assignments in place as well. So if we're talking about your IP being in a big bucket, when you're developing that IP, you want to put everything in the bucket and put the lid on really tightly. And then once you're talking about commercialising that IP, you're releasing the lid a little bit strategically so that bits can escape, but you're trying to hold on to the most of it. And then if we get some time, we may not, I'll talk to you very briefly about how to engage a lawyer. We're very specific individuals. We operate out of very archaic mechanisms, and if you can understand how we work, then usually we can work best for you. So, what is intellectual property? I bring up this slide all the time because I think it's really important to visualise, and this slide will come back. So if you miss it, don't quite understand it right now, don't worry about it, I'll explain it later. But essentially, the legal definition of intellectual property rights, there are these intangible assets, and in Australia, those are protected under copyright, patents, trademarks, designs, and plant breeders' rights. Don't worry about plant breeders' rights. Unless you're growing your own variety of grape or mango, you don't need to worry about it. But it is a protected intellectual property right. So these are all proprietary assets that the law recognises that you can monopolise, that you can exclude others from using, commercialising. The other stuff on the other side is information, things that we would normally, concepts that we would think are IP, but aren't legally recognised as IP. So we're talking about ideas. There's no property in ideas until they are reduced to some sort of intellectual property asset. Confidential information, really, really important, not protected by law. Know-how, personal information, data in databases. These are all things that aren't intellectual property assets by law. They're things you have to take extra steps to protect, i.e. in contract. So I'll start with trademarks. Trademarks as well as copyright is my jam. So we'll be talking a lot about trademarks. So what is a trademark? It's a recognisable identifier of the source of specific goods or services of a trader. Does that make any sense? Probably not. A trademark is a sign that consumers use to identify you with your goods or services. So it can be a word, logo, sound, smell, colour, or shape. We see logos a lot, that's a type of trademark. But if you think about smells, that they can also be trademarked, doesn't happen very often in Australia. I think at the moment there are 2 registered smell trademarks. One of them is for cinnamon-smelling golf tees, and the other one is eucalyptus furniture not made of eucalyptus. So, very rare, doesn't really happen. You probably will never need a smell trademark. But think about some other things that could be trademarks that you wouldn't think about. Jingles. So the Bunnings jingle is a trademark. The Smackos, does everyone remember those dog treats? Yeah, exactly. That is a registered trademark in Australia. And then there's all of these other examples. So Fortnite, that's a word mark. The sword is a it's what we call a device, but it's an image mark. The Game Loft logo, that's a composite, so it's both a word and an image device. Then we've got the Rubik's Cube, which is a shape shape trademark, so it's only protecting the shape of it. And then the Tiffany blue, if you don't recognise it. Me being very girly and, and very fashion focused, I recognise the Tiffany blue, but there's also like Cadbury. That purple is protected as a colour trademark. Issues with trademarks in particular: don't confuse a trademark with a business name. They serve two very different purposes. Your business name is what you use to trade under when you don't use your company name or your sole trader full legal name. So if you're using Game Dev Proprietary Limited, that's your company name. In order to say you trade as Game Dev without the Proprietary Limited, you register a business name to do that. Business names don't actually give you any proprietary rights in those names. So the only way to stop other people from using that name is to register a trademark. We get a lot of problems where people don't get trademark registration up front. They rely on their business name only, and they don't realise that when you register a business name, it's actually really easy for someone else to register a business name that's very similar. It's not the same. You don't get ASIC sort of vetting those names as closely as you'd think. So you could have someone else trading very similarly. They end up getting trademark registration, and you end up infringing their trademark rights. So that's one common misstep that we see with indie devs in particular. Has anyone gotten trademark registration before? Yeah? How was the process?
Tedious.
Yeah, thank you. That pretty much sums it up. This is what happens in Australia when you go through the trademark registration process. And at the moment, it's taking anywhere from 6 months to a year to get a registered trademark. You file your application. Your application is considered a couple months down the track, sometimes up to 6 months down the track. It's either accepted or you'll get an adverse examination report. Now, what happens is the examiner looks at it and goes, is it distinctive enough to actually be registered, and are there any prior registrations or applications that would trump yours? If you get that examination report, you then have 15 months to try and overcome it. So it's a really long lead time, but sometimes it involves quite a bit of work to get an examiner on board. If your application is accepted, it then goes through an advertising period, and that's 2 months. So that gives people, third parties, the opportunity to oppose your application. Usually they'll do that if they have something similar. If there's no opposition and you've just had smooth sailing the whole way through, you will have your trademark registered. If your registration is opposed, that's when we start talking about the opposition procedures through IP Australia, which is almost like being in arbitration. It's not a really formal court setting, but it's expensive and it takes a lot of time, and you don't get a hearing for a really long time. So that's when you start considering whether you need to change your trademark or whether you need to engage in negotiations outside of the IPA process, the IP Australia process, and decide whether this is really worth it. Good to know, though, before you start really investing all your time and resources into this particular logo or this particular brand name. So, as I said, trademarks are examined on two different grounds. The first one is distinctiveness. Marketing executives will tell you that it's really good to have a very clear brand that tells consumers exactly what you're doing. Yes, that makes sense from a marketing perspective. It actually doesn't make sense from a legal perspective. You don't want to... Okay, I always use plumbers as an example, and I don't know why. If I was to say I wanted to start up a business called A1 Plumbing, the problem with that is it's entirely generic. And what the trademarks law says is that you shouldn't be able to trademark, i.e. monopolise, an entirely generic phrase because other people in the industry need to use that phrase without infringing your trademark. So when I talk to my clients really early on, I say, please, please, please make something really unique. Talk about Uber. There's no real generic meaning that links us to delivery services and transport. So those examples up there, no one's from Epic here, are they? Good. Epic games. We're talking about the first word, epic, being laudatory, and the second word being entirely descriptive of what you're offering to the world. So actually, Epic Games doesn't yet have trademark registration in Australia. I've been following this for 4 to 5 years, and they still don't have registration. They've been knocked back a few times, I think perhaps because there might be some prior registrations that are blocking, but also because it is an entirely generic phrase. If you think about Blizzard, not that I really want to conflate the two, but Blizzard is that you don't talk about snow when you're like trying to figure out what games to play. It's a very unique word to describe a game studio, developer, publisher. So you want to try and get yourself in the best light moving forward to get accepted. And then it actually stops you from encountering issues, not just with IP Australia, but with other traders in the industry. You're more unique. Your consumers won't conflate between two different traders. It actually works out. Your marketing execs won't like it though. And then the second ground is conflict with early applications. So the ones I've put up there are the Kylie. Does anyone know about Kylie Jenner tried to register her trademark in Australia for entertainment services, I think. And obviously Kylie Minogue already had trademark registration and had that registration for such a long time, and obviously uses the trademark for entertainment services. So she ended up not being able to get, Kylie Jenner ended up not being able to get registration in Australia. Always good to do searches before you, yes?
Was she able to get partial registration for the online information category?
Yeah, I think so. I think what happened was they actually ended up settling out of court, and they sort of divvied up who could register what. But the thing is, you need to then use it in that respect as well. So when you get to settling with a third party, you'll talk in the settlement agreement about what you can register, but also how you can use those trademarks in specific territories, and it would have been Australia in this case. So you end up not only not getting registration, but your trade is restricted as well. So not that Kylie Jenner could have rebranded, but it's sort of a cautionary tale for us. Tips for trademarks: use it or lose it. There are processes in Australia whereby your registration can be vulnerable to removal if you don't use it. If you don't use it entirely, or if you don't use it in relation to the goods and services that you've registered. The TM and R symbols are different. You only use the R symbol if you have registered your trademark. In all other circumstances, it's really good to use the TM symbol, because you're putting the public on notice that you're using that phrase or that logo as a trademark. It also helps if you get any examination issues during registration, and sometimes you have to provide evidence that you've used it in the market, and you can specifically say to an examiner, here is where I've used it, and it's obvious that I've shown to the public that I'm using it as a trademark. It's not just a phrase that I'm just throwing into content. Yes?
So the R is legally protected, but the TM is like a...
Essentially, it's the sort of the notices that you put out to the public, and R is we're using this and it's a registered trademark. We have registered rights because the way you can pursue people for using the same phrase changes depending on whether you have registration or not. But it is actually an offence under the Trademarks Act to use the R symbol if you don't have registered rights. So for everything else, the TM symbol.
But there's no requirement to use a TM?
No, you can just use it to show that to signal to the public that you're using it as a trademark. Even after registration, trademarks become vulnerable to removal for non-use. I just mentioned that. Trademark protection is jurisdiction specific. Trademark protection is expensive. I'm so sorry to tell you that news. It is. So you essentially, if we have people who have loads and loads and loads of money, sometimes I deal with these clients, and they say, we want to register everywhere in the world. You go, well, good luck with that. We end up registering in Australia first, and then under an international convention, you can wait 6 months and file elsewhere, but adopt the same priority date as your Australian registration. Yes? Oh, it depends. So if trademark registration is, the costs are dependent on the classes that you add. So we'll get to an example of where people have applied for every single class they possibly could. That would be, you'd be looking at almost $100,000 to file everywhere, like lots of money. But what we tend to do is, like, it's not a very good strategy from a non-use standpoint as well, because your registration is vulnerable to attack if you don't use it in respect of every single thing you've registered for. So a more cost-effective approach is to look at what you're actually using the trademark for, and only apply for those goods and services. There's 45 different classes of goods and service, so you go through and go, okay, I want this class, I want this class. In most jurisdictions, your costs increase with every class that you add to an application. Ownership issues crop up a lot, particularly in Australia. So very recently we had some case law judgment was made that filing in the right entity name is really important, and if you started developing your trademark, your branding before you had a company, and then you file in the company name without actually assigning that trademark to your company, your registration is invalid. So that can really trip up a lot of my clients. Yes?
Could you repeat that, please?
Yes, so say you started working as a sole trader, you're developing your own brand, you're developing your game at the same time, you're developing your product name, and then later on down the track, you start up a company, or you start up a partnership, any other structure really, and then you go to file your trademark application once you actually have the funds in the company name or the new entity or partnership. If you haven't, at the point of making that application, assigned, so transferred ownership in that branding that you've been working on to the entity that will be the applicant on the trademark application, the application's actually invalid. And a lot of our clients have been realising that 10 years down the track, and it comes up in litigation a lot these days. It's a very easy way for someone to go, well, I don't like you, your trademark's invalid because of this. And with bigger clients who have massive company structures, it's really hard to keep track of. So, a couple of horror stories that keep me up at night. Being beaten to the register by a couple of days. If you know that something else is going on in the market, someone else is doing something similar, that names sounding really similar, do some searches. IP Australia has a really easy search function. It's obviously only Australia specific. There's also the World Intellectual Property Organisation that has a global search function. Not every intellectual property organisation around the world is subscribed to it. Sometimes in, like, I think Tonga, you need to actually front up to the IPO in person and do a paper search to find trademark details. So it won't cover everything, but it'll give you a pretty good idea of what's around. Filing in the wrong entity name, we just spoke about that. Using your name as your brand can be really hard if you decide to then sell your brand, because then you can't operate once you've sold it under your name, because you're infringing someone else's trademark that you've then assigned. So Alana Hill, fashion designer, ended up selling her company under the Alana Hill brand. She now can't operate under Alana Hill. She didn't get a license to that trademark after. That was a surprise to her. We actually spoke to her when we were talking about it to the media, and she said she was devastated because she didn't realise that this was what the impacts of actually selling that. Yes?
Do you mean to say she sold the company and accidentally sold the rights to it?
Yeah. So with the company, the sale of the company, you generally sell, I know, poor thing, you generally sell the assets that go along with the company or the business, right? And part of that is the IP assets. The IP assets were the designs that she's registered for her clothing, which honestly designers don't do that very much anymore because things change so quickly, and her trademarks. And all of her trademarks were Alana Hill. That's her name. And so she accidentally assigned all that stuff and then didn't get a license back from them to continue using it in her other business. So she can't use it going forward.
Even if the other business has nothing to do with fashion.
Yeah. If you've assigned it, you've completely relinquished ownership of that. And because those registered trademarks were registered in respect of fashion, there's a misleading or deceptive conduct issue, there's passing off issues, and there's trademark infringement issues. It's really difficult. Proceeding to market without conducting trademark searches, please do it. Please have a look. I mean, I'm really good at it if you want to engage me to do it. IP Australia has some foibles. When you're talking about doing clearance searches, please don't just type in the exact name of what you want. Do that and then start thinking about variations, phonetic variations. If I used this word and I spelt it differently, will something else come up? Because when you're talking about trademark infringement, you're protected against identical trademarks, but also confusingly similar variants. Long word marks. You only get protection for the form that you filed in. So if your word mark is a phrase, the value in that protection isn't great. Inaccurate goods and services claims, like we were talking about, where you file for absolutely everything. Really, 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 really expensive, but also not very valuable. Some examples. These guys were registered or applied to register in respective clothing, footwear and headgear. Can we see why this one might be a problem? Monster Energy opposed it and Puma opposed it. So obviously Monster Energy has the claw marks, and they also have a massive merch offering, and then sporting goods for Puma. The last time I did this talk and used this as an example, it was still ongoing, but I can see on the register that it's been settled and Puma bought them out or acquired them without paying any money, who knows. Sometimes it can be the way that things are settled, that they go, well, you'll assign it to us and we won't sue you further. Anyway, big mistake. Angry Birds is one of those people who have just applied for absolutely everything in every jurisdiction. Bleaching preparations, massage oils, makeup removing appliances, parking meters, sundials, diamonds, animal skins, curtain rails, doorstops, bird baths, but make it angry, toilet sponges, handles for dental floss, pill cases, yeast, beer, cigarette paper and cigars, all Angry Bird themed, and insurance services. Why? Well, yes, but I'm not sure that some of these things would even be legal when you think of like advertising to children. Toilet sponges, do you need to? Anyway, why?
It's easy. World domination.
Yeah, exactly right. Exhibit C and D will come up soon. Fuji-san, the Peanut Man. Not only is it racist, but this whole thing is the trademark registration. It's not separate trademarks. So unless this person uses it in this way, this is a real trademark registration, it's vulnerable to removal for non-use, but also you're not using the trademark as you've applied for, and it's meaningless. It has no value. Yep.
Sorry, what is this?
So it is a peanut company. Can't you see? It's Fuji-san, the Peanut Man. It's meant to be, I think, a group of slogans and a logo. But the person has just applied for it all at once because it's expensive. And they've just written out explainers. This is why you kind of sort of need to be careful when you file your application, or get a lawyer to do it, because there's just nothing to this. It doesn't give you any protection whatsoever. It's just so funny, I forgot to laugh. And then there's this one, long phrases as word marks. Immune booster, cool as a cucumber, Dr. Digestion, just beat it, peanut, coconut, I can't even. It's got a hashtag at the end. This is your trademark, the whole thing of it. If you don't use it in that way, you're not getting protection for it. So you can't just amalgamate all of your slogans in one and file an application for that, unfortunately. Copyright, also really important for you guys. Copyright subsists in works and subject matter other than works. What the hell does that mean? The Copyright Act was adopted from the British version in 1901. So back then we had works. We had artistic works, we had musical works, we had literary works. Subject matter other than works was something we brought in the 60s to talk about so that we could capture broadcasts, TV, films, that sort of thing. When we're talking about, we're sort of jamming newer concepts into really, really, really old legislation, which doesn't really help. There is no system of registration for copyright in Australia. There is in the US and a lot of other jurisdictions. When you create a copyright work, copyright automatically vests. So if you are the author, you are the copyright owner. Examples of copyright works: walkthroughs, character designs, the HTML code for a website, the layout of a website, the graphics on a website. It is in code, scene and setting images. If you're a developer and you write code, you are a literary author under the Copyright Act. Because code's a literary work. Yes?
So just absolutely confirming that, based on producing the work in the context of Australian law, that is automatically protecting you under the Copyright Act?
Yes.
You register it in the same way you do a trademark?
No, you do not. Yes.
But that protection would only be within Australia, right?
No, actually there are international conventions in most developed countries that recognise your rights as the copyright owner in the jurisdiction that you're either domiciled in or doing the work in. So generally, if you need to pursue something in the US and you've created the copyright work in Australia, that'll be recognised. Yeah. But we're quite a unique jurisdiction in that point. So it automatically subsists in the work once the work is created. It has to be reduced to a copyright work, so it can't just be ideas up in your head. It has to be reduced to a form that is a work or something like that.
Sorry, just a follow-up to that. How do you represent that, especially overseas? Like, do you have to present it in a certain way? Do you have to say, like...
It's not, we don't need to register it, so please...
just keep doing what you're doing?
Yeah, pretty much. When we prosecute overseas or we enforce Australian IP holders' rights, we will say, we are the Australian IP holder, you're infringing our copyright. Copyright automatically subsists in the creator. We are the IP owner. There is no system of registration, so you're not going to find it anywhere. We can be aggressive or not so aggressive depending on who's on the other end, but generally that doesn't, if you Google it, it comes up, so it's pretty easy to confirm. Character images, soundtracks, we've got a music licensing talk later on today, so I won't talk too much about music licensing, but obviously there's copyright in that, in the composition, in the lyrics, in the mechanical rights, and dialogue script. Yeah, it all sort of plays in together and you go, what's what, and how do I keep track of all of it? For you guys, branding, your logo design, that's a copyright work. If you've gotten someone to do that, not in-house, or you've gotten a contractor to do it for you, they own the copyright in your logo unless you have it assigned to you. Same thing with engaging developers or any contractors. So under the Australian law, the person who creates the work is the owner of the work unless they assign in writing and it's signed to you, or they work for you as an employee under very strict conditions. So they have to be your employee by the legal definition, so you're paying them benefits, all that sort of thing, and they create the work during their regular hours and within their regular duties, which means that your contracts with your employees can be really important. Either put in an assignment that transfers everything to you, or make sure that they're not doing anything outside of their duties, and if they're creating these sorts of things, that's what they're engaged for. Creative team, music licensing, your storyline, merchandise. Let's not talk about NFTs, I just don't want to, but just know that very traditional concepts of copyright law apply to NFTs because we don't have any other law to suit NFTs. It is a copyright work that is being minted and then assigned without a valid assignment, because an assignment in Australia needs to be signed in writing and assigned. So if you're talking about creating a work that is then going to be minted, you need to have a think about who actually owns that underlying copyright work and whether it's being licensed to the purchaser or whether it's being assigned to the purchaser to do whatever they want with. Business plans. There's copyright in business plans. There's copyright in reports. Those things can be owned. There's actually copyright in TV programs. It's anything that has had contributed to it intellectual thought and skill to create. So maybe just straight data isn't a copyright work. A spreadsheet of just straight data won't have copyright subsisting in it. But for sure, if you've had to then do something with the tables and think about where it all goes and how it all fits, that's a copyright work. Social media, content posted on social media, protected by copyright. Any works created by interns, work experience students, need to think about whether they'll be engaged just under a contract or as employees. Very rare for them to be engaged as employees. Designs. The only reason why I put this slide up is because people get confused between what a design is and what a patent is. And in Australia, we say patents, not patents. Design protects the look of something. So the way a controller appears. It's a good example of a design. This is a bad example of a design, but it is registered. The reason why it's a bad example of a design is because any one thing could be changed. It's not particularly distinctive. I don't know why you paid for it to be registered. And designs and copyright sort of overlap. So you do have to register designs. They only last for 10 years. Unlike trademarks, you can't just keep renewing them. And it entitles you to make a product that embodies the design and commercialise it to exploit it, really. There is overlap because copyright protection is usually lost once you register a design, but copyright protection and design protection is also lost if you produce in industrial quantities. So think about it before you start. If you have anything that's going to be produced in industrial quantities, or you think it will be, think about protection beforehand. Yes?
Sorry, could you define industrial quantity?
Yes, so it depends on the product, but generally we say 50 articles. That's the general rule, but it sort of depends on what the product is and what industrial would look like for that product. There are some exceptions, but they don't generally apply to your industry. Yes?
So there's a slight ambiguity in what I'm reading, because you used a controller as an example, that would have been produced in industrial quantities.
Yeah, because they got design registration first.
So it's only lost once, so the thing being lost is actually the copyright if it hadn't been registered as a design.
But designs, to register designs, they also can't have been released publicly. So you need to think about those things before you go to register a design. A lot of people go, oh, I've got this design that I want to protect. We're about to launch, it's on the website now. And I go, no, please don't do that, take it off the website now. It's too late by that stage, but some of the bigger clients will go, it's worth the risk of it not being valid because at least it's on the designs register and people may think twice about doing something similar. Patents. The difference between designs and patents is that designs protect the look of something, patents protect the function of it. Software-based inventions don't get registered very often. You don't get a patent in Australia and particularly in the US for software-based inventions. The reason is because there's sort of an air of genericism with software-based inventions. You're basically using a computer to do something, and because of that, if you're not creating an entirely new computer that does things in a very different way, the patents register won't consider it novel enough. Leveraging IP. Okay, so we know what IP is. Now, legally, what about all those other things that really should be included and protected, but the law doesn't recognise as a proprietary right? For you guys, contracts. Put it in all of your contracts. Make sure that you are licensing things and making sure that anyone who contributes to your game IP, as you guys broadly define it, incorporates those things that wouldn't technically be an IP right. So for you guys, assignment agreements, really, really, really important. Anyone who contributes to anything in your game needs to be signing an assignment agreement and an NDA, please. Licensing agreement, that's when you commercialise. So you're giving someone a right to your IP assets. Please don't transfer ownership of your IP assets willy-nilly, because you're effectively giving all control to someone else and you've lost your right to commercialise it yourself. So when we're talking about leveraging, we're talking about keeping everything in that bucket until we release little bits of it under very controlled circumstances, because that's when you can then do that for other people and other third parties and other publishers, and that's when you get the most out of what you've actually built. Employees, are they being engaged under a standalone agreement or an award, or are they contractors? I think most of the time when you're engaging people, they're going to be contractors. You don't want the risk that comes with employing people generally when you're very small and starting out, but I may be wrong. You will still want to have IP assignment clauses even in your employment agreements, even though by law, if they fit that mould of being definitely employees, definitely working within those constraints, there's always the chance that they'll do some work on the side or after hours for you, because that's the way we work these days, and it won't necessarily be captured and it won't be yours to exploit. Things to think about when engaging creative staff. The description of services. You don't want to get to a point where you have asked someone to do something, you've engaged them for a very specific purpose, and then the relationship's sort of gone on for a couple of years, they've started to do other things, and then when you look back on your contract, something goes wrong and you realise that you didn't actually engage them to do the things that they're doing now, and so there can be a dispute as to who owns what and how they might be able to take things elsewhere. So you want your work to stay with you, and to do that you need to make sure that your services, the scope of the services, are really well defined. We've gone across employment contractor. IP ownership, when you're engaging contractors, are you getting a license to the works that they're providing for you? Usually when you're engaging someone to create music, you're actually getting a license to that music, not necessarily an assignment and ownership of those music assets. And that can be fine. You have to make sure that the scoping of that is appropriate. So we're talking about, does it need to be exclusive to you guys or exclusive within a certain time frame, a certain type of game, something like that. That's when you start talking about how much do I need from them and how much am I willing to release. Warranties and indemnities. If you're engaging a contractor and you're trying to get the benefit of that IP, so you want ownership of it, your warranties should protect you, that they definitely own it. They haven't copied it from elsewhere. They haven't been using it in other projects. And an indemnity is essentially cover that if something goes wrong and you get sued by someone else, or it comes to light that they didn't actually own it, they're going to cover you for those losses. Now, none of it is foolproof. We can only do the best we can do with the words, with language, in our indemnities. So quite often you can't anticipate every single thing that could go wrong, but generally you can get to some happy medium between the two of you that goes, I want to be covered for these specific events because that's what I'm worried about. And they'll go, well, I'm being paid a certain amount, so that seems like a good indemnity to give. Reliance on third-party content. Everyone uses open source software, right? Look at your license terms. Look at the license terms for the code that's being brought to you by your staff. We don't want any viral code in our open source software. So where you are looking at a license term and you're bringing it in and it says something to the effect of, everything else in the product must be licensed on the same terms as what you've brought in. We're talking, that's what we mean by viral code in a legal sense. So essentially it means that of all of the product, everything that makes up this big massive product that this tiny little bit of open source code is a part of, you then have to license it on the same terms, on the same either Creative Commons or something like that, those terms. It means you can't commercialize it. It means it has to be open to the public to use. You can't, there's no value in the asset once you've then incorporated viral code. So you either start from scratch or you find something else somewhere else on better terms. It's one of the most boring parts of my job, but I do source code review, where I'll go through all of the license terms of open source components and go, is that okay? And it's usually when our clients are being acquired and they need to do due diligence. Transitionability. Microsoft tells me this isn't a word, but you want to be able to cut someone loose and have someone else come in and do the same work or work on what they've already developed. Make sure that your agreements, you're looking confused, no? I thought you were confused about it. You want to make sure that in the contract, there's obligations to be really upfront with having progress meetings and things like that, but also getting you to a point where if something fell through, they could just hand over and it would be very easy for someone else to come in and just keep working. So if we were talking really strict software development terms, we'd be talking about source code escrow. Doesn't really happen in games that much, but if you're dealing with big publishers. Now, I'm going to go straight to the publishing agreements. And this is all in the slides. I can talk to you about it later if you'd like, because we're running out of time. But can anyone tell me what might be wrong with this one? It's a binary publishing agreement. The developer grants to publisher an exclusive, sub-licensable, transferable, worldwide license to use and modify the apps, to reproduce, distribute, transmit, translate, publicly perform, publicly display, modify, publish, store, and create derivative works of the developer's content. And then the developer's content is all the content, such as source code, artworks, text, sounds, character designs, and logos created by the developer. Yes?
There's no limitation of the scope of work created by the developer.
Yep, definitely. I'll go straight to I've underlined it for you. It's an exclusive license. That wasn't meant to be the case in this agreement. What the developer wanted was someone to release the game, app was already done, into new markets and not change any part of it. But here we've got a license to modify. We've got a license to all of the developer's content, including source code and anything else he has ever made, for some reason. And the license is exclusive. The difference between an exclusive license, a non-exclusive license, and a sole license is that an exclusive license means you're excluding yourself from it as well. So he wasn't going to be able to keep doing the work that he was doing to spruik the game, despite the fact that this was just meant to be a marketing for a specific market, specific countries. An exclusive license prohibits him from doing any work with it further as well. Sub-licensable, it means that essentially the license that you grant to your publisher, they can then grant that license to anyone else as well. If you sort of end up losing control of how that game's being exploited, but it also means that if you are due royalties, they can, unless you have some really good legal terms around how royalties are being paid, they could then say, well, it's been licensed to someone else and I'm the only person who owes you royalties, not that other person. I'm getting the kickback from it, but I don't owe you any royalties because I'm not the person licensing the game anymore. It's happened a few times, unfortunately. The developer hereby represents and warrants to the publisher that, essentially, they own everything. And the game won't infringe any third-party intellectual property rights. That includes patent rights. Patent rights aren't very public. Something could be in the works for 5 years and you won't know that you've infringed it until you've done the whole thing and you get a letter. So it's not very commercial to give a warranty in respect of patent rights, that you won't infringe third-party patent rights. It's not often that information isn't public. What we generally do is we limit it to copyright. We say, yeah, we haven't copied code from anywhere we shouldn't have. Everything, all of the license terms of open source components are above board. An indemnity. The developer will at all times defend, indemnify, and hold harmless the publisher from and against any and all losses incurred or suffered by the publisher in relation to any and all claims or allegations, actual or threatened, that the publisher's exploitation of the game with the aim of publishing and marketing the game, oh my God, doesn't infringe any third-party rights. So essentially it's an IP indemnity, but it's so broad that you're effectively indemnifying them for anything that could possibly go wrong, even if that wasn't your fault. When you are giving your game over to a publisher, they have to accept some sort of responsibility and liability, right? The reason why you're not shouldering all that and have all the resources is because you want them to be able to take it and assume some responsibility for it. So there needs to be a middle ground. Any and all end user claims or allegations, actual or threatened. So you could be indemnifying them for some guy coming up and going, you stole my thing, even though it's absolutely unfounded. You're footing the bill for them to go through then defending that, which is just not commercial in a lot of cases. And then this was an automatic renewal clause. The automatic renewal clause didn't tie to the payments being made to the developer. So he got one upfront payment of 20 grand US, and that was for the first 4 years. And then once the contract automatically renewed in another 4 years, he didn't get any further payments. So in this example, unfortunately, we didn't go ahead. The developer tried engaging with the publisher to sort of narrow it down a bit and negotiate down, and they were absolutely not on board. So the developer decided not to go ahead. It's actually really rare that will happen. A lot of the times I say to my clients, everything is negotiable. Please don't just look at something and assume that it's done. It's a hard no if you try and negotiate. Please negotiate. The slides will be available if you want to email me, because there's also a section about how to deal with lawyers, which I think is helpful. But also, send me a message. I'm out doing some meetings for a little while and Meet to Match, but I'll be around as well. So if you have any questions, please let me know. Thank you so much for coming.